everyone. I am a young Louis Mwen, and I'm a lawyer from Cameroon who worked on MDS's African programming for over 6 years. And I would like to welcome you to this session of MDSC webinar series. I'm delighted to share with you my reflections and thoughts on the potential of using strategic litigation to combat torture, ill treatment, and abuse of people with mental disability to bring about systemic reform in law, policy, and practice in Africa. So, in this session, I'll briefly introduce torture in the disability context and what is strategic litigation. Then I'll move forward to use 4 case studies from Namibia, Kenya, Uganda as examples of how strategic litigation was used to advance public health. Basically or specifically, I'll be drawing from a report that was produced by Open Society Foundation and published in June 2016, which looks into these case studies more elaborately, and I think it's a good report that you'll be forwarded to the participants. That if you have time, it will be really great if you can read it. So after looking at the case studies, what I'll do then is try to look at what are some of the important lessons that we can learn from this case study, and consider in engaging in strategic litigation to combat mental disability related torture in Africa. Then I'll move forward to look at what are the potential benefits, or what are the potential impacts of using strategic litigation, focusing more on the Purit case, which Anne Campbell mentioned or explained during the first session. Then I'll conclude with how both you as a participant and MDSA can proceed in order to realize this venture of combating mental disability related torture using strategic litigation as one of the strategies. So in Module 1, Anne Campbell, as the litigation director of MDSA, highlighted and discussed some of the acts of torture and abuse that people with mental disability continue to experience in Africa, based on some of the human rights investigations that MDSA did in Uganda, Zambia, and Kenya, for which it was very clear from the reports that people face or experience torture, abuse, violence, exploitation at different levels, from the level of the families, level of the community, and that is looking at service providers, from traditional healers, spiritual healers, even within psychiatric hospitals where they tend to receive services, let alone the community when they engage with police, etc. But from the look of things, it shows that both the poor and disadvantaged groups are increasingly becoming targets of torture and ill treatment, and the perpetrators are both state and non-state actors. So, considering that non-state actors have also been engaged in committing acts that constitute torture. I think this is what led to countries like Uganda in 2012 to come up with a Prevention and Prohibition of Torture Act that expands the scope and definition of torture and the responsibility when it comes to torture to include acts of non-state actors like private individuals, which is definition in this Ugandan anti-torture law is much more broader than the UN Convention against torture. So we've also noticed that discourse on torture and ill treatment is commonly known to have as perpetrators police, those involved in the military, security agencies, and militias or rebel groups against individuals and especially human rights defenders. This the context in which the discussions have been taking place. And at the African regional level and national level, what we know is they've come up with anti-torture standards and mechanisms have been adopted and put in place. And countries have specifically criminalized torture or have constitutional prohibition of torture, as well as criminalizing other acts that amount to torture. But what I've noticed is in practice, the implementation of these standards in preventing torture and providing reparation for victims, it's quite and it's very concerning or alarming. So this portrays the limit of legislative enactments, probably just coming up with laws or different pieces of legislations, and unless it is accompanied with government commitment to enforce these duly enacted laws and different pieces of legislations. So different pieces of legislations. Therefore, lawyers and civil society organizations, especially human rights organizations, need to redouble their efforts to promote the effective implementation of relevant laws, which this can be done through engaging in strategic litigation and advocacy. So at this point, I wish to emphasize, or I would like to emphasize the urgent need for young and upcoming lawyers. I mean, this also including senior lawyers with little or no experience in litigating disability and torture cases, to be encouraged and provided with appropriate training and mentoring to be actively involved in handling strategic litigation in disability, torture, or human rights related cases. However, due to the paucity of disability / torture related cases in Africa, I would like I will look at some of the strategic litigation cases on other human rights issues or other issues in Africa, to draw from and reflect on how we can learn from such initiatives and how you can creatively apply the strategies in future strategic litigation to achieve an aim or to put an end to the abuse and torture of people with mental disabilities. But before I proceed, I would like us to be mindful of the fact that some particular cases may be strategic in one context, but not in another context. So, in a broader sense, when we talk of strategic litigation, we are referring to litigation that intends to impact or intends to create impact beyond a particular case and influence systemic change at the level of law, at the level of policy, at the level of practice, or even at the level of social discourse. So this means that change through strategic litigation is not necessarily or solely aimed at law or policy reforms. This can move beyond to include even aspects to do with enforcement of law and practice, and simply to raise visibility of an issue, to help also in changing attitudes. So thus what strategic litigation does is one, it tests the role of law and its proper implementation. It pushes for an equitable interpretation of laws having discriminatory impact, as well as it construct and consolidate the rule of law. So now what I'm going to do is I'll look at some of the examples that's focusing on the case studies I mentioned earlier, to look at them as examples of how strategic litigation has been used to achieve some sort of, or to push for some sort of law and policy or practice reform in Africa. And before I move forward, I would just like to note that when we look at strategic litigation in the African continent, we're all aware that South Africa has made tremendous progress in advancing the rights of marginalized groups through the courts, that's like through using strategic litigation. However, I've decided not to focus on any of those cases that were taken in South Africa, and to focus on this 4 case studies from Uganda, Namibia, and Kenya for this webinar session for 3 main reasons. Firstly, MDSA, which is organizing the training, has ongoing cases and the potential of litigation in 2 of the countries in which I've selected the case studies. But it does not mean that it's not interested in expanding its scope or to look at litigation in other countries if the opportunity arises. So I've chosen this case studies from these countries because one, MDSA has an ongoing and potential litigation in 2 of these countries, as Uganda and Kenya, and in order to draw from strategies implemented in almost similar contexts, and then that's in terms of the judicial systems, which, as we all know, is not as developed, or they are much more marginally independent when compared to South Africa. And then these cases are also more recent cases, and the marginalized groups covered in or involved in these cases share some similar experiences in terms of abuse or torture, even with people with mental disabilities, which I think makes it easier to learn from strategies used to combat torture and ill treatment of people with mental disabilities. And as I mentioned earlier, the Open Society Foundation produced a report or published this report in June 2016 that specifically looked at these cases and explained them in much more detail. So I've solely relied on this report to look at these cases and to explain the impact of the cases and the whole process itself. So I'll encourage all of you to look at this report, which is on using the use of strategic litigation in advancing public health in this country. So the report actually also looked at 2 other case studies, one from Ukraine and the other one from Canada, but I decided not to look at those cases, considering that they come from a different context, they come from a different context. So the first case that I will be explaining is the case from Namibia, that is the case of Namibia against LM and others on litigating sterilization of women living with HIV in Namibia. So the facts of the case is, in 2008, the Namibian Women's Health Network and its partners implemented a broad advocacy plan aimed at ending the practice of forced sterilization of women living with HIV in Namibia. So as part of the advocacy plan, some of the things that it did was they produced report or did research and document discrimination, stigma, and abuse that women living with HIV face in accessing healthcare in Namibia public hospitals, which include forced sterilization. And in this documented reports, they have the testimony of women, or women reported issues such as they were being given numerous papers to sign while they were in labor, including consent form for sterilization, being told to consent to sterilization if they wish to obtain access to other medical procedures, and being sterilized while undergoing C-section, that's cesarean section. And it's good to know that these women only became aware later that they've been subjected to this procedure when they were seeking access to other contraceptions. And so what this Namibia Women Health Network and its partners did was they submitted a report to the Minister of Health and Social Services about the forced sterilization of 13 women at public hospitals in Namibia, and requested the minister to want to investigate the issue, to hold to account those responsible for this grievous act, and asked the government also to provide training on informed consent to the country's public health care workers, and then move forward to the Namibian Women Health Network. It moved forward to engage the media also to raise public awareness of the practice and enlighten women living with HIV of their rights or their right to refuse sterilization. However, despite all the actions taken to engage the government and to have the government to address this problem, the Namibian government dismissed the action and claimed that these women that were sterilized, they signed the appropriate consent forms. Thus, it was not a fault on the part of the doctors, and did not hold the training that was requested. So the Namibian Women Health Network decided to engage in litigation, in strategic litigation, to put an end to this practice. So in 2008, they filed a case in the High Court of Namibia, argued that forced sterilization violated the plaintiffs' common law right to bodily and psychological integrity, and their constitutional rights to life, to liberty, to dignity, and to be able to form a family, and to be free from cruel, inhuman, and degrading treatment. They also allege that the forced sterilization on the basis of these women HIV status violates their constitutional right to be free from discrimination. So the trial the case was concluded in January 2011, and partly due to delay resulting from the government procedural objections. So all the three women who took for this case, they all testify, and their testimonies was, or the evidence and testimonies was supported by expert opinion, that is by a doctor who examined the women. And in July 2012, the Namibian High Court ruled that all three women had been sterilized without their informed consent, which violates Namibian law. And the High Court went forth to set out what are some of the components of informed consent, and held that patients should be informed of the advantages and disadvantages of all contraception methods, including sterilization. However, the High Court did not find the argument or the allegation of discrimination, or did not find discrimination on the part of the government for lack of sufficient evidence to link the sterilization of the women to the HIV status, which I mean is much more some sort of the strategy, depending on how, I don't know how they went for to get their evidence to support the discrimination claim. So it's something you can also be reflecting on. And the Namibian government decided to appeal the ruling or the decision of the High Court, and the Supreme Court later on in November 2014 ruled in line with the High Court and affirmed the decision of the High Court, noting that none of the three women gave informed consent because they were in varying degree of labor and may not have fully and rationally comprehended the consequences of giving consent for the sterilization procedure. But then, I mean, these were very, very successful decisions or successful litigation, strategic litigation, but it was not a standalone strategy because there were also some actions that accompanied the litigation. So what some of these actions included advocacy that took place at the community level, at the national level, regional and international levels even, led by the Namibian Women Health Network and its partners. So what they did was civil society organizations focus on awareness raising in the community using rights-based arguments on women living with HIV. That's the group that was subjected to these procedures. They were mobilized and then they were even packed in the courtroom during the trial and the appeal hearings. So at the national level, these organizations also took action to engage the traditional leaders to get their support. And then petitions for submissions to the Ministry of Health and Social Services were prepared and circulated. They also organized sit-in at public hospitals and marches to the court, as I mentioned, took place. That's at the national level. At the regional level, some of the actions that took place, they had stakeholders organizations submitting letters to the gender unit of the Southern African Development Community, the SADC, as well as to the Special Rapporteur on Rights of Women in Africa to inform them of the practice of forced sterilization in Namibia. The African Human Rights Commission, that's the commissioners, were notified, and this actually resulted with the commission querying the Namibian government. What some of the partners also did was they raised the issue of forced sterilization of women with HIV in Namibia at the African Dialogue of Global Commission on HIV and the Law, which was attended by the Deputy Minister of Health and Social Services. At the international level, the stakeholders organizations submitted letters to 3 key UN special procedures. That is, this mechanism that were established by the United Nations Charter. So, the special procedure on the right to health, on the right on the right of people not to be subjected to torture. That's a UN Special Rapporteur on torture, and violence against women. They were all, these 3 UN special procedures were engaged. So not only those even, and then I think report also says that the Southern African Litigation Center also submitted a parallel report to the CEDAW committee. That's a committee, the committee against the committee for the elimination of discrimination against women, which actually covered it in its concluding observation based on the parallel report that was submitted on the issue, or covering or mentioning the issue, or a parallel report that included the issue of sterilization. submitted by this Southern African Litigation Center. They also had a broad media campaign by which sensitized local and international journalists. They issued press releases, opinion pieces in media outlets, and took effort to circulate updates on court cases using blogs, etc. However, when you look at the impact of this case in Namibia, you realize that in Namibia and across Africa, it raised awareness of the practice and its rights implication, especially for women living with HIV, who now became informed and empowered. We've actually noticed that in Kenya, women have come forth to also challenge this practice and seek redress in court, and reports have been published on the issue of the practice of forced sterilization in Lesotho, and I've also learned that in Swaziland they've actually in the process of anticipating to take court action on the same issue. So at the level of the impact when it comes to the health outcome, it's a little bit mixed, because the fact now that in most of the hospitals for women who genuinely and voluntarily wants to undertake this procedure, they are required to sign affidavits, for which some of them now is a challenge to get the affidavit, and they don't want to get into that process, probably to be engaging with the police, get lawyers involved to obtain an affidavit. So to some of them they find it as a challenge, but the government is also here to agree on the damages with regard to the case, and that's as of June 2016. As I told you that I read this from the report that was produced by OSF. So we don't know if the government has done anything yet on that, but it says the government is here to agree on the damages. And one shortcoming of the judgment is the women sought just monetary damages. So as opposed to if they would have decided to seek or to get a much more comprehensive remedy. That's something that I'll leave it for you guys to reflect on. And the second case is a case of it's a case that took place in Kenya. That's Oshane and others against the Attorney General. That was a case of 2009 before the High Court of Kenya, which they decided to engage in litigation to protect access to life-saving HIV medications. So in 2008, that's with regard to the facts of the case, in 2008, Kenyan passed the Anti-Counterfeit Act, that's commonly known as ACA, aimed at protecting trade in counterfeit goods. What the act does is it limits access to safe generic medications and significantly limited access to antiretroviral drugs by people living with HIV. Since under the act or under the law, patent right holders could ask the Anti-Counterfeit Commission to seize all generic antiretroviral, as this is on the list of counterfeit goods. So as the issue is, when the Kenyan parliament was still debating the bill, that's before it was passed, civil society coalition made submissions advocating for it to be amended. But this never happened, so the civil society organizations decided to use the courts to seek redress or to address the issue. So with regard to the litigation, the civil society organizations and organizations of people living with HIV in Kenya sought immediate interim sought an immediate interim ruling for the court to stay key provisions of the legislation. Why they strategize on how to challenge the sections as violating the 2010 Kenyan Constitution. So in 2009, 3 individuals living with HIV and represented by their lawyers sued the Attorney General in the High Court of Kenya, alleging that relevant sections of ACA, that is Section 2, Section 32, and Section 34, would affect their ability to access affordable and essential medicine. And we learned that the case, they had 3 petitioners, but from what report says is other potential petitioners or people that were also interested in the case, they had to decline because they were scared of having some sort of public exposure as a result of the lawsuit. So what the plaintiff in this case argued is that the section would, these sections of ACA would infringe your right to life and the right to highest attainable standard of health protected by the Constitution, and also contravened the HIV and AIDS Prevention and Control Act, which require states to take measures, or which require the Kenyan government to take measures to ensure availability and affordability of essential medicines to people living with HIV. In April 2010, the High Court issued interim orders staying the sections and restraining the Anti-Counterfeit Agency from enforcing those sections as regards importation of generic drugs. Civil society organizations went forth to engage UN Special Procedures also, because they requested the UN Special Rapporteur on Health at that time, Anand Grover, to submit an amicus, which in the amicus, the Special Rapporteur explained in detail the content of the right to health, as well as complex issues regarding patents right, or in relation to patents rights. So in April 2012, the High Court of Kenya finds the above, or the sections of ACA to be in violation of the Constitution, and specifically picked on Section 2, which defined counterfeit, or defined what constitutes counterfeit, and then requested the government to amend it and bring it in line with the Constitution. The court refused the government claim or argument that this law, that's ACA, purpose was to protect people living with HIV from counterfeit medicines, but found that it seems to protect more the intellectual property rights of the patents holders. So it's quite interesting to note that the government did not appeal the High Court's decision. So, but before they even get into the litigation itself, some other broader actions accompanied the strategic litigation. So this involved, they had some sort of a comprehensive plan around media, like the media strategy, which helps to sensitize journalists on the issue. And the case was covered widely on issues of access to generic medicines, and marches were also organized, and then they also mobilized people living with HIV to be present in the courtroom during the hearings. So with regard to the impact, this OSF report noted that over 400,000 people living with HIV were able to continually secure access to the antiretroviral drugs, and it helps also to raise awareness at the sub-regional level, that's within the East African community, and actually resulted in civil society organizations in Uganda using this judgment or this decision to defeat a similar bill that was in Uganda, or that they want to they want to enact in Uganda. So civil society established special relationship with the UN Special Procedures, which is quite a remarkable impact. And even though the government, the decision or the judgment specifically asked the government to make amendments to Section 2 of the Act itself, which it did, the civil society organizations have been quite critical of the amendment itself, and but no, as of now, no action has been taken to probably challenge the current amendment, since it was merely cosmetic. However, it was reported that post-advocacy strategy, that's after the judgment or post-judgment advocacy strategy, was not quite concrete, so which makes it a challenge to challenge this amendment. The next case study that I would like to explain is the case of Arora against Kenya National Examination Council, and another, and was a case of 2013 before the High Court of Kenya, which the litigation was to secure gender identity. So, as regards the facts of the case, transgendered people in Kenya have difficulty to obtain identification documents that feature their correct name and gender. So, in order to raise awareness of the right of transgendered people and secure their rights, the organization named Transgendered Education and Advocacy, in short T, that's TEA, is a Kenyan NGO. It decided to use strategic litigation as part of its broader advocacy strategy to push for its objective, or to achieve its goal. So, with regard to the litigation, or as regards the litigation, in 2013, Audrey Mbungwa, which is who is the founder of T, that's the Transgendered Education and Advocacy Organization, decided to file a petition in the High Court of Kenya challenging the Kenya National Examination Council to change her name and remove her gender marker on her school certificate. So what happens was her name and gender on her school certificate were different from those on her identification document, which made it difficult for her to get a job, and as a result, subsequently, she experienced depression. Audrey alleged that the Kenya National Examination Council's refusal to make the changes that she requested was unreasonable, was unjustified, was unfair in the circumstances, and was in breach of the rule of natural justice, and was in bad faith, and all this were against her legitimate expectations. So the Kenya National Examination Council opposed her claim based on the argument that changing Audrey's name and gender marker on her school certificate would lead to fraud and was expensive, and it was Audrey's responsibility to prove her identity and qualification to potential employers. And and that the documents clarifying Audrey's medical conditions were vague and was unclear whether any gender transition has occurred. So, despite the government arguments, the Kenyan High Court dismissed all of the Kenya National Examination Council's argument because there is no legal requirement to include a gender marker on school certificates, while also invoking the right to dignity, and move forward to order the Kenya National Examination Council to change Audrey's name and remove the gender marker from the school certificate. The Kenyan High Court drew its reasoning from jurisprudence from the UK, from India, and also from precedents from Kenya regarding the recognition of a third gender. And so the Kenya National Examination Council has appealed the decision. That's to the appeal court, and the case is still ongoing as we speak, or as of June 2016. But to the best of my knowledge, the case is still ongoing. So if you look at also what are some of the actions that T, that is the Transgender Education and Advocacy Organization, did, was they also mobilized and provided support to transgender people, and try to engage, or they actually engage the government to secure protection for transgender community, while also providing training to key stakeholders. So T also filed several cases, seeking to strengthen the rights of transgender people, which some of these cases include seeking court order that the government should register T itself as an organization, and addressing or combating police brutality of transgender people, compelling the government to issue guidelines on surgery for transgender people, and to change the names and photos in national identity cards of transgender people. So T also went forth to hold training for lawyers prior to taking up these cases on issues affecting the T's community, and convince some of the lawyers to assist them with some of the cases. As concerned the impact of the case, we could see that the case actually significantly increased public awareness on transgender people and their issue in Kenya, and also helps to draw the line and make the difference between transgender community and homosexuality, what it means to be gay, lesbian, and bisexual, etc. And then also, it has helped a lot to mobilize the transgender community and raise awareness among the community on their human rights. It has also helped to increase the organizations as T's profile in Kenya, as of learned that there have been cases where T has even been invited by members of parliament to come and educate or enlighten them more on the transgender issues affecting the transgender community. So this has also inspired, as I mentioned earlier, it has also inspired other transgender litigation in Kenya. But in terms of impact, the consequences have also been mixed, because we've heard of a case where one of Audrey's doctors was harassed, and which made the doctor become a little bit reluctant to work more on transgender issues. And one thing that I found quite interesting when I looked at this report produced by Open Society Foundation with regard to this case, is that even though the court affirms Audrey's right in the case. It also failed to refer to her as a female throughout the decision. And the last case study that I'll be looking at is the case of it was a case in Uganda taken up by the Center for Health and Human Rights and Development, that's a CEHUD, which is an organization that MDSC is currently one of MDSC's key partner in Uganda in engaging in strategic litigation, and we are currently working with CEHUD in one of its litigation, or in one of its ongoing cases in Uganda. And this was a case that was filed in 2011, and CEHUD decided to use a dual approach. While it petitioned the Constitutional Court, it also took for the civil suit against the local the district local administration, the area. So the whole purpose of, the aim of this case was litigating to ensure effective maternal health care in Uganda. So as to the facts, there's this lady, Irene Nanteza, who was admitted at Nakaseke hospital in Uganda at an advanced stage of level, and she was not attended to by a doctor for more than 8 hours, and later on she and her baby died as a result of that. So it seems as if maternal mortality seems to be a systematic issue in Uganda. So in order to address this, CEHUD and 3 others decided to use strategic litigation. And with regard to the litigation, in 2011, CEHUD and 3 others sued the Attorney General of Uganda in the Constitutional Court, alleging that the government failure to provide basic maternal health care to expectant mothers was unconstitutional. However, in June 2012, the Constitutional Court ruled that the case somehow raised a political question that were better addressed, or was better for it to be addressed by a different branch of the Ugandan government. So CEHUD decided to appeal the decision of the Constitutional Court to the Supreme Court, and in October 2015, the Supreme Court rejected the ruling or the reasoning of the Constitutional Court that the case raised a political question, and remanded and sent back the case to the Constitutional Court to hear and make a determination on the merits of the case. And actually, one of the Supreme Court judges held that in this case, the Constitutional Court is required to determine whether the government has provided or taken all practical measures to ensure the basic medical services to the population, which in this particular case was maternal services. And so that was one trend of the case. So CEHUD and this lady's family also sued the local government of Nakaseke in 2012, alleging that failure to attend to this lady for over 8 hours violated her right to be free from cruel, inhuman, and degrading treatment, and a right to equality guaranteed by the Constitution. They also asked for, or they requested for, general and punitive damages. In June 2015, the High Court of Uganda found the local government liable for violating Nanteza's constitutional right, and ruled that the local government is responsible for the administrative and supervisory oversight of the Nakaseke hospital. At this point, I think it's good to note that CEHUD, or it's good to highlight, or to be cognizant of the fact that Sehud has litigated other individual cases on access to maternal health, and in all of these cases, it decided to sue the local government for failure of the district hospitals to provide adequate health care rather than the individual medical personnel, or challenging them in terms of suing against them for negligence, probably using a tort, as a violation of tort law. So, based its argument on constitutional rights rather than medical negligence, and highlighted much more of the structural and systemic nature of the problem. So, it did not focus on thus pushing the government to punish the individual medical personnel without addressing the the whole structural problem in itself. So, some of the actions that accompanied the strategic litigation or the litigation bid was that Sehud formed a comprehensive strategy to end maternal mortality in Uganda. So it set up a coalition of community-based organizations. It engaged and sensitized the media, held press conferences when the case was filed, and also alert the media when the High Court, actually when one of the High Court judges visited the hospital for fact-checking. So in terms of the impact of the case, this is the first